Oh, kalau saya dah start tak boleh masuk lagi ni diorang ni. Aduh, okey. Okay, Bismillahirrahmanirrahim. Okay, as I said just now, we are going to look into the auditor's legal liability. Yeah? Okay,
Right.
okay, these are the topics. Yeah, you can see that it's a long list, but it's actually not. Yeah. However, the slide memanglah you look that the slide there are altogether about 40 plus slides. So we're going to look at the legal environment and rising litigation, limiting liability, statutory gap, etc., expectation gap, the key terms, okay, for the legal issues, and then the governing laws. And then after that, we're going to look at the types of liabilities, and then the cases. So all here are actually important lah here. So you cannot miss any of this. Right, this is actually the latest, not to say the latest lah, but this one is 2018 case regarding the auditor, yeah, the auditor PwC, that the court, the Federal Court of the US, has actually made decision against PricewaterhouseCoopers, yeah, for the reason that did not design the audit to detect fraud. Yeah, to detect fraud. Earlier, we have covered issues related to fraud kan. Kita dah cover kan issues related with fraud, yeah. That when the auditor plan the auditor has to design the audit procedure in a manner that he should detect error and fraud. Yeah. So you can see here that the PricewaterhouseCoopers did not design its audit. Yeah, that means did not plan the audit in such a way that they were able to detect fraud. So that's why the judge here go against the auditor. And the amount you can see there is actually a lot lah, yeah. Okay, right. This is the litigation against the auditor and the settlement by the auditor. This is actually covering the period 1995 and 2016. Yeah. So this is actually the peak of the litigation cases against the auditor. And before 1970s, litigation against the auditor is not frequent, but the peak is around this period. Yeah. And nowadays, the litigation against the auditor is not so, the trend is not so highly increasing. Yeah, there are cases, but it's not highly increasing. Right, this is another, the litigation settlement. Ada orang yang baru masuk tu. Okay, dah. So you see that now in 2013, 7 billion, yeah, that is actually asked from the auditor because of some issues, and that some issues with the auditor. However, later the trustee for TW here, I can't remember TW here, decided to settle the issue privately, and they did not disclose the amount. And in 2008, again, the issue with PwC, PricewaterhouseCoopers, okay, the amount of settlement is 1.1 billion. You can see that banyak, ya. In 2019, ada juga kes pasal auditor in the US. ya, tapi not as frequent as during this period lah, not as frequent as during this period, ya. Okay, why is it this litigation against the auditor is increasing? Now, this is actually the theory lah, the rise in the litigation. The reason for the rise of the litigation cases against the auditor. All right, in the US, during those time, yeah, the professional auditor were required to take indemnity insurance, meaning that they have to buy insurance. Yeah, the auditors are required to buy insurance. So if let's say somebody has insurance, yeah, somebody has insurance, then if let's say you are not happy with that person, so you tend to sue the person, because if let's say you are successful, then the court may require that particular person to pay you back. And here that person can pay because that person can pay out of insurance money. So likewise with the auditor, they have to get this indemnity insurance, and also in the MIA by law actually require auditor to take insurance. So this the plaintiff, who is plaintiff? Plaintiff is actually the one that initiate action against the auditor in court. Yeah. So they feel that the auditor has a lot of money because the auditor has indemnity insurance, and that situation is known as deep pocket. So that is one of the reason why the plaintiff decided to take action against the auditor. Okay, soalan lagi belum masuk. Okay, and then the other issue, the other reason or the factor that rise in litigation is due to contingency legal fee. Now, if you remember contingency fee for auditor, what does it mean? It means that the client of the auditor is going to pay the auditor if, let's say, the outcome of the audit is according to the interest of the client. Yeah. If it is not to the interest of the client, then the fee would be much reduced. So in this case, contingency legal fee applies this is actually applied in a similar concept, yeah, where the plaintiff that sue the auditor or take action against the auditor will pay the lawyer the legal fees if, let's say, they win. If they lost the case, then they don't have to pay. All right. So that is actually one way of contingency legal fee. Or it could be that if they lost, then they are going to pay only minimal amount. So there is no risk actually to the plaintiff if let's say they lost the case. Okay? And then the other factor is because of the jury system. If let's say you don't understand or my voice is not clear, can you please say so, yeah, interrupt me, eh? All right, another factor, as I said just now, is the jury system. Yeah, the jury system. Okay, the jury system is where in the past they have this jury system. Nowadays, not so lah. Yeah, even in Malaysia, previously we used jury system, but now we no longer apply jury system. Jury system is where the court will have a group of jurors, a group of jurors, that means individual, that will be listening to the case, yeah, the lawyers to the plaintiff and the lawyers to the defendant, the plaintiff, now, the person who initiate the action against the auditor. So usually the auditor is the the defendant party. So the lawyers to this plaintiff and the defendant, they will actually bring the case and argue, yeah, in front of the court and in front of the jury. The jury is made of maybe about 12 members like that. If you see British drama or British movie, past, yeah, old movie regarding legal case, you can see that there are a few members sitting listening to the case. Yeah, about 15, 16, more than 10, I think. Yeah. So this jury system, the members are actually can virtually be anybody. Yeah, it can be, you see here, it can be the layman. Even the layman can become the juror. Yeah, the layman can become the juror. It can become the juror. Salah tu aja tu, spelling salah ni rasa dia tak ada T. Dia layman, M-E-N sahaja, ya. L-A-Y-M-E-N, ya, tak ada T. So it can be even student to listen to the case, housewife. It can also be professional, but maybe not lawyer lah, maybe can be medical professional. So this jury system is where, the court will summon, will send letters to the public randomly, asking them or calling them to become the juror, to sit in a given case that they have assigned, and then listen to the case. So when we listen to the case, the head of the jury will discuss that. Okay, dah cukup dah. Jangan keluar-keluar lagi, ya. Hopefully internet is okay. Okay, the head of the jury will discuss among the other members of jury and finally make decision. So you can see that the people that make decision, they may not be professional. So they listen to the case and they might not understand the case, the arguments put forward by the lawyers of the plaintiff and the defendant. So because of this, the plaintiff actually take the opportunity to sue against the auditor. Okay, the other factor is actually because of the class action. Class action is actually a group of people who feel that being deprived or being suffer damages due to the auditor's action. They collectively take action against the auditor. So for example, like 10 people, they were affected because of the auditor's report, which they claim that the auditor have given the inappropriate audit report and also inappropriate audit opinion. So when when 10 people joining together to bring action, so here you see that if, let's say, they lost the case, they are not going to pay so much because they share the cost of the litigation. If they win, then there is no problem because they get apa tu dia panggil award, damages. Yeah, they get damages from the auditor. The court will ask auditor to pay damages, so it's okay if they win. But if they lost, then the loss will be shared among 10 of them. I mean, 10 is just an example lah. Class, yeah, it could be depending on those who were affected. So if let's say they decided to be, uh, come collectively to charge or to sue the auditor, and then they will share the cost. Okay, another factor is due to audit expectation gap. Okay, audit expectation gap is because they feel that usually the case would be related to fraud. Yeah, where they feel that the auditor is responsible to detect fraud, and you know that auditor has no responsibility to detect fraud, right? Everybody? Auditor's responsibility, main responsibility of auditor is actually to what? Give opinion about the financial statements. Hmm. So, auditor has no responsibility to detect fraud. However, it's only when the auditor design the audit plan. Remember the case, the first case that I've showed to you just now, the first few slides, that the auditor were charged because the auditor did not design the audit to detect fraud. Correct?
Yes.
Okay, good. So you see that because they feel that auditor is responsible to detect fraud, so that's why they decided to charge the auditor, and that is actually wrong. Yeah, and then the other factor is due to audit complexity. Yeah, audit complexity. So because of this complexity, you know that, well, compared to previously about 10 years ago, even 20 years ago now, audit is actually becoming more complex, right? Because of this globalization, yeah, the company is complicated, not a very straightforward company. They are maybe transnational company, maybe they are in internationally connected subsidiary or the parent company from overseas. Yeah, and then not only that, the system now, we have this internet where the transaction are borderless. Yeah. So due to this, the plaintiff feel that the auditor has not done enough lah. Yeah, and there might be issues where they feel the auditor may lack of knowledge, lack of skill in performing the audit, and thus have given opinion which is not appropriate. So they feel that they were deprived and therefore take action against the auditor. Okay, the next factor is litigious climate. Litigious, it means that this is a situation where you see the table that I showed to you, that most of the action taken against the auditor were between 1995 and 2015, 16, something like that, right? The reason is because, when these plaintiff, they heard of one case where has auditors were sued, then they feel that they would also like to sue the auditor due to the losses that they have suffered. Yeah. If you relate that to Malaysian case lah, artis, yeah. In Malaysia, famous kalau saya dengar in the news, it will be the artist lah. You hear artist would like to summon another artist, and then another artist summon the press, etc. And Malaysia kan dia macam, yang tu lah banyak yang saya dengar dalam media lah, ya. So that is what we say litigious climate, ya. Kalau katakan tak ada orang yang nak saman, rasa saman tak? Taklah kan. So that is what meant by litigious climate. Yeah, the climate or the environment where everybody sue everyone. I mean, somebody sue someone, and then another pula sue because of that. Yeah. So these are a few factors lah why that there are litigation cases against the auditor. Yeah, in
All
Malaysia,
right.
litigation against the auditor is not that known lah because it's not been exposed. Yeah, unless we go through the legal document tu, then mungkin kita boleh carilah. Yeah, so that is actually the uh, Malaysian the Malaysian environment lah, yeah, on legal case against the auditor. So we do not really know, yeah. Right. So I said just now that increasing in litigation against auditor between the period 1995 and 2015 or 16 just now, yeah. Then after that, with this, they see that this is actually a study lah. They see that the trend is actually a little bit declining, yeah, declining. Yeah, so this is actually what I have gathered from the internet. Yeah, so investors' lawsuit against auditor are falling, and that's bad news for capital market. Bad news because the lawyers lah, yeah, they have less cases now lah. Yeah? So so the reason is actually why this is declining is because of the fraud issue lah. Remember, if let's say auditor is being sued by the plaintiff due to fraud cases, right? Tapi in this particular study, they said that uh, no or less cases against the auditor due to fraud. It means that if you relate back to the expectation gap just now, expectation gap is where people believe the auditor is responsible to detect fraud, right? So that's why they sue the auditor. So now it means that most of the people now understand that auditor is not responsible to detect fraud. So that's why they feel that there is no need. I mean, it will not be benefiting them if they take action against the auditor uh, due to fraud reason. So that is actually what this article is all about. So maybe if you would like to read, you can go through this the website. Yeah.
All right.
Okay, and then in the past too, usually the plaintiffs are institutional investor. So when we say institutional investor, they have money to sue the auditor. You need money to go to the case, yeah, to go to the court, yeah. If you would like to initiate, you need to have money. It's not small amount; it's actually large amount of money, yeah. So in the past, it's actually most of them are the institutional investor. Yang tadi tu, yang case, yang the first case I mentioned tu is actually the institutional investor lah that bring the case, yeah, and they were successful. Okay. All right, and then a court dismissal case against the auditor as defendant are going up. So now there are many cases against the auditor where the court are in favor of the auditor as defendant. So it means that most of the plaintiff would lose in the case. Yeah. So that is actually the reason. Now these are actually the finding from this study. Yeah. And essentially the ability of the class or group of investors. Remember class action just now? Class action, few people who feel that they have been deprived by the action of the auditor come together and so these two has weakened. So last group now is going to come together to sue the auditor. So this is actually the finding from this article. Right. The rest I think you can read for yourself lah. Yeah. So this one is actually for your interest. Yeah. So So far, kalau dalam examination dia akan tanya pasal kenapa uh, plaintiff sue auditor, the reason why. Yeah, so you have to remember the factors just now. Yeah. All right. And here, just now is about the declining trend of charging the auditor. That is the percentage of those who charge the auditor. But this one here is actually the trend of charging. Why is it they charge? Yeah? So if you look at this one here, the reason is blame. Kejap yang ni. The likelihood of auditor litigation is strongly related to the types of alleged accounting deficiency. Accounting deficiency meaning that the accountant is less knowledgeable. So dia bukan kepada, not because of the auditor are rarely blamed when there are allegations of financial reporting failure. Salah ni ya. So here, dia bukan blame because of the financial reporting failure, but being blamed because of the accounting deficiency, meaning that the auditor is less skillful. Accounting is actually here in this sense is a verb. A verb meaning that accounting. Apa maksud tu? The methods that the auditor carry out the audit work is not satisfactory lah, yeah. So it's less skillful. So not because of the financial reporting failure, yeah.
Okay.
Okay, so here, this is actually the trend now lah, yeah. But this trend is actually not increasing. It's actually, if let's say the plaintiff is successful, it may be due to this. Right, so what do you have to do in the case of legal liability? Well, when there is a charge against the auditor, it will affect the profession's reputation, right? It will affect the audit firm itself. Also, it will affect the auditor that carried out the audit work or the audit partner. So that's why this legal liability has to be controlled in a way. Yeah. And there are a few ways that this liability can be limited. Yeah. Now this limiting liability can be viewed from three angles. The first is by the profession, the second is by the audit firm, and the third is by the audit partner himself. Yeah. So all these three perspectives have to consider about how to limit the liability or how to reduce the legal liability. Okay, so one way is actually to cap auditor's liability, and this is actually example in Australia. Cap auditor's liability meaning that if let's say the auditor lost the case, yeah, the plaintiff win the case, then there will be a maximum amount that the auditor has to pay. So it cannot be beyond certain amount. So that's what meant by capping auditor's liability. Okay, boleh faham?
Jadi maksudnya kalau company tu nak sue auditor tu ada limit lah boleh sue.
Bukan, kalau plaintiff menang dia akan dapat certain amount je, maximum amount.
Maximum amount lah.
Certain maximum amount tu how much we do not know lah, yeah, but it's only up to certain amount kalau dia menang. So will not be, that means plaintiff tu dia will not get the whole amount that he suffered the loss. Yeah? Okay. Kalau kita kira lah kan, kalau katakan saya nak sue somebody, saya dah rugi ini, yeah? So and so much. Okay, so amount dah ada. Then you menang the case. Katakan saya menang the case. Tapi I will not get all. I will get only up to what been decided, that what has been kept as auditor's liability. Okay.
Alright.
Okay, incorporate audit liability. Incorporate audit liability is where limited liability. Kalau limited liability company, what? Kalau if the, let's say company has liability, yeah, has liability, and let's say company has problem, become insolvent. So how the company is going to pay the creditor? They are going to sell off the asset of the company and then pay the creditor. Will it be selling personal asset of the directors and so on? No.
No.
So similarly, incorporating audit firm, meaning that they are trying to limit that, meaning that the audit firm become limited liability audit firm. And this is actually a reality now. In Malaysia, yes, we have the limited liability audit firm. Limited liability, although that they are partnership. Biasa kalau audit firm partnership kan. So the audit firm may choose whether to have ordinary partnership or they can have the limited liability partnership. Okay. So this one has been in practice for many years already lah. Sorry, tak adalah many je lah. Yeah. But I can remember. I think in mid 2000, 2005, 2006 macam tu lah. Saya pun dah tak ingat dah. Tapi baru lagi lah, recently lagi lah in Malaysia. Recent pun dah 10 tahun lah. Yeah. Okay. And then the next one is to have the proportionate liability. Proportionate liability. Let's say how many of you in class? 22, right? Can? 22 of you in class. Let's say all of you decided to join together to form audit firm partnership. Yeah, audit firm partnership. And all of you, let's say, are all partners. All of you are all partners. So that means if let's say you have client, let's say ya, saya tak berapa ingat sangat nama you ni, mana yang saya ingat tu lah ya, macam Imran ingat lah ya. Let's say Imran, okay, is in charge of one client company, in charge. So that means he is audit partner. And I saw Kashiah tadi, Kashiah is a partner too. Semua partner, tapi Kashiah heading another client company. And then everybody of you has your own client company, but the profit will be shared among you kan, among the 22 of you, depending on the partnership agreement lah. Ingat tak partnership?
Yes.
So will be shared among you depending on the partnership agreement. Yeah. So kalau let's say kita ambil 3 orang lah, senang ya. 3 orang senang nampak sikit lah. So 3 partners. All partners, they agree that okay, A dapat 3 out of 6. Partner B dapat 2 out of 6 profit ya. And partner C dapat 1 out of 6. Yeah. So that is actually the proportion for sharing the profit. Don't ask me kenapa. You have to go back and refer to the partnership, yeah, accounting. Right. So whenever that they have this business, okay, the business. If let's say A is to get 3 out of 6, B is to get 2 out of 6, and C is to get 1 out of 6. So whatever amount, it will be divided among them according to that ratio. Yeah. And then if let's say loss, ya kalau loss, it depends juga lah, depends on the partnership agreement. Tapi in auditing, in auditing, it's not in that way. In auditing, if there is a loss, loss in the past, kalau katakan A, A has been sued. A has been sued and lost in the case. So A will have to pay. But A is not only the one that is going to pay the plaintiff. B and C too has to pay the plaintiff. So that is what meant by joint and several liability. Alright? Faham
Faham.
Okay, tapi so this one, therefore, it will be not fair to B and C sebab B and C tak ada pun terlibat dengan audit of company A, of partner A and the client kan. So it will not be fair. So that's why to limit, they have decided that it will be replaced with proportionate liability. So if let's say B and C is not involved in that particular audit, then only A will have to pay, not B and C. But if if let's say B and C also involved in the audit of A, because boleh tak? Boleh kan? Because one client, dia boleh ada a few audit partners kan? So kalau B and C terlibat, then according to the proportionate liability, then B and C too must make the loss. You must make up the loss, but not the same amount as A lah, depending on the proportion, certain proportion. So this point here is actually related to the introduction of the proportionate liability, right?
Okay.
Right. Contributory negligence. Okay. Contributory negligence is actually another way of limiting. So we said plaintiff. Plaintiff is usually the plaintiff. I do not want to mention who is the plaintiff, but you know who is the defendant kan? Defendant is the auditor lah. Yeah. So let's say plaintiff sue the auditor and found auditor is negligent. Yeah. Or found or the court award against the auditor. That means in favor of the plaintiff. But if let's say the plaintiff, let's say the auditor can prove that the loss suffered by plaintiff is not only due to auditor, but it's also due to plaintiff himself. So it will not be fair to, it will not be fair to auditor to pay all damages to the plaintiff, because part of the loss of the plaintiff is actually due to himself, is caused by himself. Yeah. So something like this lah. Let's say I'm the plaintiff, you are defendant. Yeah. Bukan salah. Saya tak nak jadi plaintiff. Okay. Let's say A and B jugalah ya, A and B. A is the client, B is the auditor. Okay, A auditor lah sana. A auditor, B is the client. Yeah. So the client sue auditor. Yeah. B, the client win the case. Yeah. Due to, the reason maybe they say the auditor is negligent. Yeah, I will talk about negligent later. Yeah. So, B menang the case. Yeah. And the court will award B. So when that happens, A will have to pay B. Yeah? A will have to pay B, whatever amount. But A can claim that A mengaku that okay betul lah saya salah, ya. Tapi awak pun salah juga. Kenapa awak buat gini gini gini? And if that reason court accept, then auditor will only pay damages to B according to his contribution to loss. So if B suffered the loss due to himself, that will not be paid by A. So it means that rugi je lah dia sebab it's due to his own action, client's own action, right? So that is what we say contributory negligence.
Okay, madam.
Faham ke?
Madam.
Ni.
Maksudnya kalau auditor tu berjaya buktikan yang tu adalah contributory, so judges tu akan set lah portion berapa bagi-bagi loss tu.
Ya, betul.
Okay.
Alright. So that is contributory negligence, and this is actually limiting the auditor's liability too. Okay, so just now limiting liability ni the one that I have actually discussed with you. These are actually should be on the initiative taken by the profession lah, betul tak? Kan, taken by the profession and also by certain ministry, betul tak? So it's actually the certain body, certain organization, within the country. So it cannot be by the profession itself. If you see here, capping auditor's liability or incorporate audit firm. So dulu tak ada partnership limited liability firm kan? Sekarang ni dah ada. Tapi macam mana boleh dapat operate partnership limited liability firm? Of course, it has to get the support from the government. Correct? So this one here, usually, this is actually the government support towards the audit profession. Yeah. So government support. Yeah. Similarly, contributory negligence, government support. Okay. Now, next we are going to look at the profession pula. The profession like MIA. So how MIA can reduce the exposure, because it will affect the MIA. Kalau so many charges against the auditor, it will affect MIA. Yeah. So these are actually, what the profession can do. So profession can establish stronger auditing and assurance standard. So you can see the auditing like macam accounting standard. Accounting standard keeps being maintained kan, changes here and there. Betul tak? Updating. Right? Similarly, in audit profession, the auditing standard too is being updated. That means to make sure that everything would be in place and also to cater for the new changes in business environment. You see that you may not see lah, yeah, but in my case I can see that the business environment has changed a lot, yeah. So dulu very different from today, yeah, a lot different. So that's why we need to, or the profession need to constantly upgrading the auditing standard. And then to do the research in auditing, yeah, the best way lah, yeah, in whatever method, best way so that it can reduce the audit liability. Yeah, so research here may be in terms of not only basic, but research into maybe to have certain system, better to have certain system ke, ataupun would be the best way to do the audit. And then educating the user, educating like for example expectation gap just now, right? So that has to be announce to people that it's not the auditor's responsibility to detect fraud. Okay, and continually updating the code on the professional ethics. So this one similar lah, but this one is the professional ethics, the MIA, if you remember. MIA. So MIA also keep constant updating. Yeah. Establish peer review. Okay, this is actually the quality control on the audit work. So if there is quality control on the audit work, then the auditor may carry out audit work properly, so there would be less litigation against the auditor. And then lobby for changes in the law, lobby. So the profession responsibility is to lobby the law. So that's why and here you can see that the profession has successfully lobbying the law. For example, the introduction of the partnership limited liability company, and then in Australia, capping the auditor's liability. And then not only that, we have the contributory negligence. So that is actually as a result of lobbying for changes in the law. Okay, what about the individual? Let's say you are the audit partner. You are the audit partner. Yeah. So what do you have to do? Okay, dekat sini saya tak ada. I don't have the firm, yeah. Okay, tak apa. Afterwards, yeah. Okay, so individual, you as auditor, what do you have to do? So how do you maintain your quality as auditor? And remember, as audit partner, you have to make sure that your client is the one may not give you problem. Yeah. So what do you have to do for that? You have to investigate the prospective client. Yeah, you have to investigate your prospective client to make sure that they will not bring problem to you. They might not put you to the court. And then we deal with clients possessing integrity. Yeah. Obtain an engagement letter and a representation letter. So this is actually to support you. When you have the engagement letter, you know what engagement letter is. If you can remember, then go back to your notes in part 1 audit. Yeah. So these letters, this is actually to protect you as evidence. If let's say any issue arises regarding matters that been included in this engagement or representation letter, then you can highlight and take this as evidence to support you. And then maintain independence. Yeah, this is actually important because most of the auditor, like in the case of Enron, the auditor is not independent. In fact, auditor helping the company or Enron to manipulate. And then maintain confidential. Yeah, maintain confidential. Right, then more. Here, hire qualified personnel and train them. That means your staff. Yeah, your staff, you are audit partner, your staff. You have to train them, make sure that you get good personnel. And then follow the standard, the auditing standard, the accounting standard, you must follow them. And then perform high standard of quality. So how to perform that means you have to follow the audit standard. Yeah. So by following the audit standard, accounting standard, it means that you perform with quality. Document the work properly. Yes, this is because the evidence, it can become evidence. If you did not document the audit work, then it will be risky because if there are issues, then you have no evidence to support you as auditor. Yeah? So you have to document. Now document doesn't mean physical document. Nowadays a lot of software, betul tak? So must keep that lah, but make sure that the documents are not being created lah. Yeah, so there's proof that it has been in existence on certain date and file that properly. Next, alert to risk factor that may affect result in lawsuit. Yeah, so you have to be alert to that, because if you are, negligent, yeah, that likely you as audit, yeah, you as auditor can be taken to the court. Maintain adequate professional indemnity cover. This one, remember about the insurance just now? So auditor has to take insurance cover, yeah, professional indemnity cover. And this is actually a must now because it is in the MIA bylaw. The MIA require all auditor to take insurance cover. And not only that, the insurance coverage has to be adequate. Yeah, it's not just simply take certain amount, but make sure that if let's say something happen, you will be able to cover the cost of the court. Yeah. So that's about the individual accountant. Yeah. Okay, what about the audit firm? Audit partner. Sorry, I'm not here. The audit partner, of course, they have the firm, betul tak? Regardless lah whether it's sole auditor, ya, ataupun partnership audit firm, ya. So that means the firm. So what the firm has to do? The firm has to abide to the uh, rules and regulation tu lah. The firm must make sure that they have the standard operating procedure in place. Yeah, they must make sure that the all, let's say, partnership audit firm, they must have the agreement in place, and they must make sure that all members follow the auditing standard, follow the MIA bylaws, and also they must have policy and procedures of how to engage client, so that these partners only get client who have integrity, yeah. Also to ensure that the audit partner will not be involved with client who lacks integrity or is actually involved in criminal activity. Yeah, so they will have these policies and procedure. Also policies and procedure relating to how to document the audit working paper. Okay, for the individual, you say that you as audit partner, you have to document. But then the audit firm too must have policy that all audit partners within the firm, they have to, follow certain procedure to make sure that the documents are being handled properly, yeah, and being kept in certain manner, yeah. Also, the audit firm, they may, in order to reduce exposure, always send them for training. Yeah, go for training so that all partners are updated with their knowledge and skill, because the accounting standard, auditing standard keep changing. So these partners, they have to keep abreast with these changes. So they have to attend seminar, they have to go to courses, they have to take examination, extra examination, for example. So that is actually the policy that the audit firm has to implement to ensure that all partners within the firm follow the rules and regulation, to make sure that they are always keeping abreast of the new updates, so that there will be no issue of incompetency. Now remember, auditors' competency is very important, yeah, in audit. So if auditor cannot display that competency, there is a possibility that the auditor may be charged. Yeah. So these are some of the things that the audit firm has to consider. Another thing is about the quality control. The quality control. So the audit firm has to ensure that the partners maintain to the quality control. Yeah, right. So anything about that? I hope it's clear. Yeah, the audit firm. Okay. Is it okay to continue? What's the time now? I cannot see the time. Okay.
Yes, can.
10 o'clock. Ooh. Okay. 10 o'clock now. Okay. Banyak lagi ni. Okay, so that is actually the first thing that you have to know about audit liability. Yeah, kita boleh continue ya.
Alright.
Okay. Now, next is actually we are going to look into some cases of the some legal cases that involve auditor. Yeah. The cases against the auditor. But before we go into that, you have to know certain legal terms. Yeah. First is about the privity. Privity. What does it mean by privity? Privity, it means that, okay, if you look at the what's in front of you here is a contractual relationship. Lack of privity means the accountant may not owe a duty of care to an injured third party. Now that is the standard meaning of privity. Privity is actually about closeness. Yeah, about closeness. The closeness between the auditor and the client. Yeah, how close they are. How close. So if let's say the relationship is bind due to the contractual agreement, do you think that that is actually close, very close? Yes, very close. For example, like in a marriage, akad. There is akad, a contractual relationship, right? Is it close, the husband and the wife? Yes.
Yes, close.
If let's say you and your friend, is it very close? I mean, certain very friend, close friend. Is it close? Yeah, close friend. That too can be privity, but less as compared to the one that have contractual agreement, like macam the husband and wife very close, yeah, because they can stay together. But by contractual agreement in business, very close, but they cannot stay together lah. Yeah, close friend maybe not yet, married, then very close lah. You can, I mean, ladies and lady lah, a lady and a lady lah, yeah, and men and another man, yeah, they can, maybe stay together. So privity, it means about closeness, yeah, about closeness. But the term refers to a contractual relation, a contractual relationship. It means that there is a contract that binds the two person. So that is what meant by privity. Yeah, yeah. All right, then, so the privity here, the term privity can be, applied in different situations. You will see later. Remember this, what I have said to you just now. Okay, breach of contract. I think this one you know lah, yeah. Somebody breached the contract, that means did not fulfill the terms of the agreement. Yeah. Tort. Okay, what is tort? Okay, a wrongful act other than a breach of contract for which civil action may be taken. So, dia tak ada contract. Kalau contract is bound by the contract law. But tort is, tort, there is no contract, there is no law applicable. But it's actually something that somebody can bring action due to certain reason. But bring the action in civil lah. Civil, it means that secara umum lah, yeah. meaning that for general purposes. Let's say, yeah, okay. The most common the most common case is actually about a classic case in the UK. A classic case where this one person, they bought a canned drink tu ginger beer lah, ginger beer. So the consumer tu beli ginger beer, beli air lah, senang beli air dalam kotak, from a retail shop, so not he, she consumed that ginger ale, ginger ale or ginger beer lah, she consumed that, and after that she discovered there is a decomposed snail inside that. Faham tak? What I'm talking about? Dia minum, lepas tu dia tengok ada snail apa? Siput. Ada siput yang dah mati dalam ginger ale yang dia minum tu. Kalau kita terminum tu, what do you do?
Saman company tu.
So dia dah muntah. So dia pun sue. Dia beli dekat kedai kan. Dia beli dekat kedai. Tapi dia tak boleh sue yang kedai tu. Cannot sue that kedai. Because dia tak ada kontrak. Dia ada kontrak dengan kedai tu, receipt kan. Betul tak?
Betul.
Tapi that shop is responsible ke tak for that canteen has decomposed snail.
Tak.
So she sued the manufacturer. So that is actually under tort.
Oh, okay.
So there is no contractual agreement between she and the manufacturing, right? But she sued and she was successful lah. Another classic case is about a customer buying shirt, and after wearing the shirt, saya tak ingat ada nama case. That is actually very interesting lah nantinya, and I still remember that. This was about many years ago that I went through these cases. So this consumer bought shirt, and after wearing that, I can remember lah, he or she, the person has developed rashes, and that person sued the manufacturer and was successful. So that is tort. So you can actually bring action, against that. And in fact, if in Malaysia, example would be, let's say, kan naik motor, kalau naik motor biasanya on the road, and then after that there's a hole on the road, and suddenly the person who drove the motorbike just now fall off due to that. That can be taken too. That legal action can be taken too, and that is also under tort. Ramai, maybe some of you didn't know about that, but it can be taken. Ramai lawyer yang sanggup buat yang tu, sebab of course lah is one way of getting their income, but the motor rider just now may seriously injured in this situation, right?
Yes.
Motorists can actually take action against the appropriate authority under tort, under civil action. So yang tu memang pernah terjadi to one of the family members, but then we did not take any action lah, just to inform to you. Okay, ordinary negligence. What is ordinary? You have to differentiate this with the gross negligence. Now, ordinary negligence. Let's say, this is absence of reasonable due care in the conduct of the assignment. And then UCAT is evaluated in terms of what other professional accountant would have done in similar circumstances. Simple carelessness without attempt to deceive or commit fraud. So it's simple carelessness. Yeah. Okay. Differentiate that with negligence. It's an extreme, flagrant, or deliberate and reckless or thoughtless departure from professional standard of due care. So let's say, yeah, uh, uh, as auditor has to audit sale invoices. Yes, sale invoices. And then the auditor came across this, one of the invoices, and then the auditor feel that it's not according to the normal sale invoice that he has came across, but he just simply, ignore that. He ignored that, and then he considered to be part, the amount on the sale invoice is considered to be part of the sales figure, which has to be taken to the profit or loss account statement. Yeah. And okay, if he also considered that the same the auditor would be doing that lah. So that is actually what we say ordinary negligence. He saw something that is not right on the sale invoice, but he just tend to ignore that, yeah, because he feels that there's nothing lah, yeah. It could be unique to the company or to the client company, yeah. Okay, gross negligence is something that, let's say that particular invoice just now, yeah, has a certain figure which is so unreasonable, yeah, so unreasonable that he feels that, well, something might be wrong, might be wrong, but he just simply ignore that, yeah. So from the invoice just now, he said that, oh, this is not right, something is wrong here, the amount is so ridiculously high, yeah. And then also maybe some of the staff have mentioned, I mean he or she overheard from the staff that about the issue, yeah, and he tend to ignore that. That is what meant by the gross negligence. So between ordinary and gross is severe cases. So if auditor is, found to be seriously or been committing gross negligence, then most likely he will be sued and he will lose that in the court. Yeah? Ordinary negligence may at least can be a defense to the auditor. Okay, fraud. You know what is fraud? I don't have to mention that to you lah. Huh? Okay. Error, you know what is error. Okay. So the law governing the auditor. The law governing the auditor and ada ni pula elimination. Okay. So these are the laws regarding the auditor. We have the statutory law, we have the common law, we have the contract law. Contract law, I have mentioned to you just now, right, is binding the two person due to contract. Clear, yeah, everybody? So the two parties are bound by the contract. Okay, in audit and client, is it bound by the contract? Yes, because we have the engagement letter. The engagement letter is actually a contract between auditor and the client. Yeah. Statutory law like Companies Act, yeah, Capital Market Services Act, Law Act, that is statutory law. And this statutory law, some of this law bound the auditor. For example, auditor has to follow or not Companies Act? Yes.
Yes.
Auditor has to comply or not with Act? Yes.
Yes.
Okay. That is statutory law. What about common law? Common law just now lah, related to the tort just now. Yeah, the tort just now. So it's the law that applicable to other than the law that we have in practice. All right. So this one is about the types of the liability and the auditor's action resulting in liability. Yeah. For example, like common law liability to client, common law liability to third party, civil liability under statute. Civil liability, remember thought just now to bring action against the other party under civil action, that is civil liability. Yeah, and then criminal liability, that means this is a jenayah. Yeah, so kalau jenayah usually related to statute lah, the statutory law. Yeah, so so let's look at this one dulu. Auditor would be liable under the statute lah kalau the liability, criminal liability in violation of the statute. So this one is definitely auditor salah lah ni, yeah, because go against the statutory law. Kalau civil liability, this can be due to negligence and gross negligence. Okay, what about the common law here? Common law, kalau to the client or to the third party, common law can be due to negligence lah or gross negligence. Tapi kalau the client, kalau satu lagi contract, ya, contract law. Remember the source just now, contract law between auditor and the client, right? So the auditor can be, summoned under common law under breach of contract because of the engagement letter just now. Okay. Okay. So I think I would like to start up to there. If I were to continue, then it will not be appropriate point that I will stop. So until here only lah. Yeah. Panjang lagi ni. Panjang saya. So for the moment, we just look at, the types of liability and the auditor's action resulting in liability. Anything to ask about this?
No.
Usually in class pun about this legal liability, it will be 2 lecture. It will be two meetings lah with the students. So nampak gaya macam tu juga. I thought that I can finish all, tapi kita start lambat tadi kan. Alright, so on Monday I will continue with this, yeah. Monday kan? Yeah.
Okay.
Yeah, I will continue with this.
Madam.
Yeah.
If MIA by law, it is
Yeah.
categorized under what law? Common, civil, common or statutory?
Okay, MIA by law, that is, okay, by law. Definitely it's not statutory. Yeah, it's not statutory. Okay, contract is not a contract. Contract, that means kena sign everything kan, both parties have to sign. Okay, so it's not contract, not statutory. Okay, is it under common law? Most likely it will be under common law. Tapi that one is actually internal matters. Yeah, internal matters. So if let's say the auditor breach ataupun the auditor did not comply with the MIA by law, so can the MIA bring action against the auditor? Usually no. Usually no. It will be penalty, betul tak?
Yes.
Unless the auditor is engaged in a criminal activity. So and one of the MI bylaw say that auditor, remember section 150 about the professional behavior. Section 150 of the MIA bylaw. Ingat tak? Professional behavior, which require the auditor to abide to certain rules and regulation. Kan? And then also the auditor has not to be involved in any criminal activity. So under that particular situation, then the auditor can be, if let's say found, auditor can be charged under civil.
Okay.
Under civil liability, under statute, because it depends on what kind of breach. Kalau yang under statute ni, nampak ni yang bawah sekali ni, statute under criminal liability under statute, it's going to be violation kan. So the auditor can be charged under certain law. So it will not be initiated by the MIA, but the MIA will actually report that to the authority, and the authority, the police or the SPRM will take action against the auditor lah. So it will be passed to the authority. Tapi kalau yang kes yang lemah, yang biasa-biasa tu, warning sign lah, penalty ke, ataupun bar the person from becoming the auditor, tu je lah. Right?
Alright.
Anything else to ask? No question.
No.
I'm going to give you the slide here. Go through the slide. Make sure that you faham. Then after that, maybe in the next class you can ask me. Yeah.
Okay, madam.
Okay. So, Assalamualaikum warahmatullahi taala wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Semua hadir Okay, alhamdulillah. Tak ada bunyi suara perempuan, boy.
Suruh meeting pula.
Okay. Bye.
Bye.
Thank you, madam.
Okay.
Thank you, madam.
Ya, sama-sama.